Lecture 2, International Court of Justice 1, Organization and Jurisdiction of the Court 1. Main issues. The ICJ is a permanent court which is empowered to exercise contentious jurisdiction to decide interstate disputes on the basis of the consent of the state parties to give advisory opinions to the UN organs and specialized agencies. The ICJ is a principal judicial organ of the United Nations. The ICJ was established by the Charter of the United Nations as the successor to the PCIJ. The ICJ came into existence with the election of its first judges in February 1946. The seat of the court is established in The Hague, the Netherlands. In contrast to the PCU, which was not an organ of the League of Nations, the ICJ is the principal judicial organ of the United Nations. As an organ of the United Nations, the ICJ is supposed to contribute to achieving purposes and principles of the organization by its strictly judicial activity. Given that a majority of international disputes are settled through negotiations, the role settlement seems to remain comparatively modest in international dispute settlement. However, it is not suggested that the ICJ performs merely a marginal role in this field. Rather, the court's role is crucial for at least 4 reasons. Parties before the ICJ. Under Article 34(1) of the ICJ statute, only states may be parties in cases before the court. Neither individuals, international organizations, nor component states or federations can be party. To be party to a particular case, a state must be one of those to which the court is open or having access to the court pursuant to Article 35 of the ICJ statute. Under Article 35(1) of the statute, the court is open to the state's parties to the present statute, and any such state can submit disputes to the court. As noted, all members of the United Nations are ipso facto parties to the statute of the ICJ by virtue of Article 93(1) of the UN Charter. A state which is not a member of the UN may also become a party to the statute of the ICJ subject to conditions to be determined in each case by the General Assembly upon the recommendation of the Security Council in conformity with Article 93(2) of the Charter. Election of judges. The court shall consist of 15 members, not 2 of whom may be nationals of the same state. Under Article 2 of the ICJ statute, the court shall be composed of independent judges elected regardless of their nationality from among high moral character, who possess the qualifications required in their respective countries for appointment to the highest judicial offices or are jurisconsults of recognized competence in international law. The members of the court are to be elected for 9 years and may be re-elected. 5 judges are elected every 3 years. At every election, the electors shall bear in mind not only that the persons to be individually possess the qualifications required, but also that in the body as a whole the representation of the forms of civilization and of the principal legal world should be assured. 4. Independence and impartiality of judges. Independence and impartiality of the judges who compose the court are a prerequisite to secure the authority of its decisions. These elements are also essential to obtain the idents of states. The requirement of independence is clearly provided in Article 2 of the I statute. The court shall be composed of a body of independent judges, elected regardless of their nationality from among persons of high moral character. The judges of the court can be considered as independent, so long as there is no external source of control or political influence which prevents them from acting in an autonomous fashion. The requirement of impartiality is provided in Article 20 of the ICJ statute. Member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. 5. A national judge and judge ad hoc judges of the nationality of each of the parties shall retain their right to sit in the case before the court under Article 31(1) of the ICJ statute. The participation of a national judge is defended on the ground that it will be useful to ensure that the case presented by his or her country is fully understood, while S is required to act impartially. 6. Chambers of the ICJ cases are heard by the full court unless the parties to a case request that the case be heard by a chamber. The ICJ embraces 3 chambers under the ICJ statute. I. The Chamber of Summary Procedure. E. The Special Chamber. And E. An ad hoc chamber. A judgment given by any of the chambers provided for in Articles 26 and 29 shall be considered as rendered by the court. 7. General consideration about jurisdiction. The jurisdiction of a court or a tribunal signifies the power to decide a dispute in accordance with law. The exercise of jurisdiction of the ICJ must rest on the consent of states, and no state is bound to submit its disputes with other states to the court without its consent. A state's consent can be given via 4 different ways: special agreement, E. A compromissory clause in a treaty, in forum prorogatum, the optional clause.